Good morning, everyone, and welcome to this month's risk management, risk reduction class, where we're going to discuss some challenges that agents are facing due to the NAR settlement. And I want to be sure to give you as much information possible to address some of these challenges to make it a little easier for you to adapt to the way you do real estate, to conform with the new regulations, new rules, the new forms, all of it, give you a little insight on how perhaps to handle these challenges. Some of this information is going to be a review of what I've said before. Some of this information you already know. Some of this information might be new to you, or at least might be worth reminding you of it, because all of the information I'm going to share with you is quite significant in your ability to successfully prosecute your real estate career, serve your clients well, and just as importantly, staying out of trouble as you do that with the new guidelines. Real estate has changed significantly. It's been stood on its head. If you're brand new to real estate, you're probably saying, what changes? But for those of us that have been practicing real estate for more than a couple of months, especially more than a handful of years, this is a completely unique and new way to move forward as we represent buyers and sellers. So let me get right into the presentation. We're going to have a Q&A afterwards. Let me share my screen. And let me get my PowerPoint up if I can find it. There it is. All right, everyone can see that, I hope. And as always, start off with how to contact me, and call my direct line during business hours. It's the best way to reach me. If you call my cell, I will respond, but maybe not as quickly, because I don't keep my cell in my hand or right next to me. Well, it is next to me, but I'm focused on my emails and my phone calls and the face-to-face meetings that I'm involved in during business hours. Of course, you can always email me, and evenings and weekends, don't hesitate to contact me. Texting is probably better because I will notice that quicker. And if you're working, my goal is to be available to you as much as possible. So don't hesitate to call me evenings and weekends as necessary. Okay, let's talk about 3 challenges that agents are facing due to the NAR settlement and the practice changes that were necessitated by the lawsuit and NAR settlement. The first is, we're going to talk a little bit more in detail. We've covered it a little bit in the past, but I'm going to get into it a little bit deeper. How do you deal with unrepresented buyers? And then, as sort of a corollary to that, dual agency is going to be more common as well. Unrepresented buyers are going to be more common. Dual agency is going to be more common. And I want to remind everybody of fiduciary duty. And it's you have to be especially careful in dual agency to be sure you're not violating your fiduciary duty. And then finally, I want to remind everybody about seller concessions and the rules around that. My biggest concern is you don't get fined. I'm already hearing, not in our company, but people are getting fined for trying to, in some cases, innocently, inadvertently breaking rules about what you can put in the MLS. Some people a little more creative. There's not much tolerance for being creative to try to get around putting commissions in the MLS. So we'll talk about that. So let's jump into each of these. Let's first talk about working with unrepresented buyers. As a result of our settlement, there will be a rise in unrepresented buyers. That's one study recently completed revealed that 70% of transactions with unrepresented buyers failed. So that's going to be a challenge for us. There are going to be more opportunities, maybe opportunities is the wrong word, more situations where the buyer will want to proceed unrepresented, and to keep in mind that there's a few challenges to being in a transaction when you are the listing agent with an unrepresented buyer. And we'll talk a little bit about that going forward. So as a listing agent, you want to talk to the sellers about, the NAR changes, basically, that for an agent to work with a buyer, they have to have a buyer representation agreement. In California, it's a BRBC, a buyer representation or broker compensation agreement, or a SPRA, which is a property showing and representation agreement. That's sort of a short version of the BRBC. We talked about that the last time we were together. So I'm not going to do another class on those two. You just need to explain that to your sellers, that buyers are going to have to, or agents, buyers agents rather, buyers don't have to, buyers agents have to have the buyer sign an agreement. I want to make that clear. I sort of misstated it, started to misstate it. There is no regulation that requires a buyer to sign a representation agreement. That would be probably unconstitutional, quite frankly. There are regulations requiring agents who are licensed and regulated by state of California and all the other states to have buyer representation agreements when they work for buyers. Currently, I think 19 or 20 states have such a regulation. California will have one starting January 1. All NAR members have to have one starting the 17th of this month, which is already come and passed. Now, the agreement specifies the compensation to the buyer's agent. The buyer is responsible for that. So you want to explain that to your sellers. You can use the broker compensation advisory to help you with that a little bit, but you're going to want to, at a listing presentation, discuss with the seller the changes relative to how buyers are paid. And the fact that the compensation of a buyer's agent can be paid by others is certainly an option, including the seller you're talking to. But if it's not, the buyer would be ultimately responsible for it if the buyer were to have representation. Now, obviously, so an agent to work with a buyer, this is required, the BRBC and SPRA. That's a duplicate slide. All right. Some buyers will elect to avoid this and go unrepresented. That's the point. You want to bring this up to your seller. Some buyers, once they see that agreement, they're not going to want to sign an agreement. They're not want to take on that obligation, even though it's possible to have others pay it for the buyer. The agreement doesn't waive the fee if someone else doesn't pay it. No buyer's agent is compelled to work for free. So you want to point this out to your sellers. They're going to make offers. These unrepresented buyers who want to avoid paying agents are still going to buy property. They're not going to say, oh, gee, now, buyers agents have to have agreements. I don't want to sign one, so I guess I won't buy a house. That's not going to happen. So you're going to be dealing with unrepresented buyers. They're going to be coming forward to buy a house without representation. There's a higher likelihood the transaction doesn't close because no one's walking the buyer through the process. You want to begin to prepare the buyer, for this concept. And as part of your RLA, your listing agreement, you're going to see in a moment, there's a place to be compensated if the buyer does not have representation, a place for you to be compensated, not to represent the buyer. It is not dual agency. It's for the extra work that you're going to go through to work with an unrepresented buyer. The transaction doesn't close often with unrepresented buyers because nobody's walking them through the financing and appraisal process, the disclosure and inspection process, the repairs and final walkthrough process. These are all sources of turbulence. That's a phrase I've often used in my seminars in the past. Turbulence in a real estate transaction. And that's what agents get paid to help buyers navigate that turbulence, that rough water, if you will. Buying a house is not smooth sailing. You're going to hit stormy weather. Agents know how to get buyers through that stormy weather. If the buyer doesn't have an agent, nobody's getting them through this process. All the things that go into the entire process. the highs and lows that are part of every transaction. Part of the skills of a real estate agent in general, and I would say a buyer's agent in particular, is having a little knowledge about how to deal with the psychological issues that a buyer presents to an agent, because buying a house is very stressful. And so there's challenges. You have to be counselors as well as real estate experts to help buyers navigate and get to a successful close. An unrepresented buyer doesn't have anybody doing that with them. See, buying a house, and I make this point all the time. If it were easy, you wouldn't need a real estate agent. I don't need anybody to help me get water out of the tap. I turn the valve and it comes out. Anybody who's going to make a career of helping people get their drinking water or their bath water, yeah, probably not going to go very far, because it's pretty simple. Buying a house is not simple. It is not complicated. Okay. Now, when dealing with an unrepresented buyer, another point you want to make to your seller is the seller and the listing agent are going to be exposed to more potential liability because no one's advising the buyer. So the buyer is going to make, what I would say with love, stupid decisions. I would never say to a buyer, you're making a stupid decision. But in a seminar, I often use the phrase, people don't do stupid things for stupid reasons. They think they have a good reason, but they still do stupid things. Again, not dialogue, it's an attitude. See, a buyer will close on a house, has no representation, and then later he'll sue over a problem or issue that wasn't adequately addressed from the buyer's perspective during the transaction. Nobody's advising the buyer. That's the problem. Sounds like a broken record, but you want to make that point. So the dialogue you want to have with a seller at a listing appointment, before we encounter an unrepresented, prepare them in advance. Sometimes the tips are worth more than the content. One of the best ways to deal with objections is to prepare the other side for the objection before it comes up, because then it seems normal. A little side note here. I don't want to do too much side notes. I'll never get through this, but I always prepared buyers when I first met with them that there may be a possibility I'm going to ask them to write an offer quickly. You fall in love with a house and it's everything you're looking for. Would you want to go home and think about it? By the way, ask questions. Yeah, of course you would. Yeah, it's a big decision. You're going to spend the next 10 years in this home, maybe a longer time than that. You're going to want to think about that, right? What happens if I show you a home and then I find out while I'm showing it or shortly thereafter, because you're interested and I have a question for the listing agent, that there are 3 other offers on the home and they're presenting the offers tonight? See, would you want to just pass on the house, or would you want to make an effort to get the house? If you love the house, I'm going to recommend you make an effort. So I might be asking you, hey, we got to write an offer. Now, the wrong time to do that is when you need to write the offer. Oh, no, we got to write an offer right now. There's 3 other offers. See, handle it in advance. Okay, so before we encounter an unrepresented buyer, we got to make a few decisions, Mr. Seller, Mrs. Seller. First, do you want to even accept an offer from an unrepresented buyer? And again, you can go back to those 2 points I made. The likelihood of it closing is a little less. Maybe in San Diego, because there's such low inventory, buyers are going to hang in there and buy the house. But still, nobody's helping the buyer. The buyer could easily fail. And second, more liability. No one's helping the buyer. And then after the fact, the buyer, gets the help he should have got during the escrow and now wishes he hadn't bought the home. So do you want to even accept an offer from an unrepresented buyer? Or instead, require the buyer to obtain representation? A seller can do that. I've confirmed that with the very top of Car Legal. Yes, a seller can say, I will only entertain offers from buyers who have representation. So talk to the seller about that. Do you want to do that? And then second, if we do elect to proceed with an unrepresented buyer, how much additional cost will be involved? To prepare the seller, for the fact, I mean, you're going to tell them right now because you're going to present the RLA, but this is a way to present that second paragraph for additional compensation for an unrepresented buyer. This compensation for me to do twice as much work, and just as importantly, agents, a lot of times agents talk about the work. I often talk about your time. Time is what you sell, quite frankly. Time and expertise. That's what you sell. You have a limited amount of time. You cannot help all the buyers. There's not enough time in the day to help to do that. So it's going to take more of my time, which means less time for other income producing activity. I mean, would you object, Mr. and Mrs. Seller, if I take another listing or help another buyer or seller buy a home? Of course not. I can't make a living only doing one transaction at a time. So if I work with an unrepresented buyer, that's going to suck up some of my time that I would normally give to another client. Now I can give it to this transaction, but I would want to be compensated. Try to take the word need out of your dialogue. I need to be compensated. People respond negatively to the word need. You need to do this. No. If you want to, get this house, you're going to want to write the offer. That's a much better phrase than if you want to get this house, you need to write an offer. People don't like, being given directions that proceed with the word need. You need to do this. I think it comes from a lot of us. Our mothers told us we need to straighten up and clean our room or else. I don't know where, but we don't like the word need as people. Okay, so more time holding the buyer's hand throughout this entire process. Normally, a buyer's agent's going to hold the buyer's hand. I'm going to hold your hand. The buyer's agent's going to hold the buyer's hand. If I represent a buyer who buys your house, I'll be compensated by the buyer to hold his hand. I'll be compensated by you to hold your hand. This is the kind of dialogue. Choose your words. Don't use mine if you don't like them. But come up with words that make the same point. More time, because I'm going to end up writing or rewriting an offer and counter offers, because we're going to want it in the right forms and in the right format to protect you, Mr. and Mrs. Seller. Be with them for inspections and revisits. Normally, the listing agent doesn't sit at the inspection. Certainly, the listing agent doesn't meet the mother-in-law who's in town to show the new buyers, show the buyers the new home they're going to purchase. But I'm going to have to do that. Why? Because if I don't meet the mother-in-law, this buyer may walk away. And my job is to get this escrow closed for you. But that's going to take more of my time. Provide documentation to their lender. Again, buyers agents work with buyers lender. We're going to confirm their qualifications, to verify their funds. But as far as doing all the little errands and legwork and extra paperwork, that's on the buyer's agent, not the listing agent. But if we have an unrepresented buyer, in order for this to close, because that's my mission, get you to Buffalo before school starts, I'm going to have to be working with their lender in a more detailed way, not verifying that the loan's moving along. That would be my job as a listing agent anyway. But it's to do all the documentation that the lender might require. Following up with them throughout the entire escrow process, them being the buyer. You've got to have this conversation with sellers at the listing appointment. You've got to talk to buyers about unrepresented buyers, because it's a fact. You're going to get them. And when a buyer comes forward and says, I don't need representation, that is not, and they want to write an offer. Oh, gee, okay, well, I need to call the seller and figure out what we're going to do next. The seller may well say, no offers from unrepresented buyers. The seller may say, no, I want to sell my home. I'm not going to worry about whether they're represented or not. Okay, well, then I want some compensation for that. I mean, that's not dialogue, that's an attitude. Okay. Unrepresented buyers can be very problematic. You want to make that point to the seller. It can take a lot of your time and a higher likelihood of not closing and greater liability potential. Sort of a summary of what I've sort of presented to you to present to your sellers. Now, the NAR settlement requires any real estate agent who shows a house and represents a buyer must have a representation agreement, and it will state compensation the agent will receive. This agreement makes the buyer ultimately responsible for the buyer's agent's compensation. Some buyers will be not willing to sign an agreement. will decide to purchase the home without representation, and the buyer will approach the listing agent directly to purchase the house. Sort of summarizing what I went through. So the listing agent, when approached by a buyer who is interested in buying a home, you've already had a conversation with the seller about what are we going to do. And either you're going to not entertain offers, or you're going to hopefully be compensated, because the seller is not going to say, no, no, I don't care if they're represented or not, I need to sell my home. So that dialogue's already happened. But now you're having a dialogue with the buyer who calls you up or come to the house and wants to, they're interested in the home. So you've got to ask if the buyer is represented. Buyers who attempt to go unrepresented often are unaware of how complicated the process is. Maybe that's the first thing you say. Well, not maybe, it is what I would say. The first thing I would say to a buyer, do you realize, how complicated buying a home is? Would you be surprised to know that there are a lot of factors that go into buying a home? And I don't want to spend time in this class to list all of them, but there are, NAR has a list of, I think, 170, and then an additional list of 105 things. So that's what, 275 things that agents get involved in with selling a home, whether they represent the seller or the buyer. So you want to be able to talk a little bit about the complicated process of buying a home. They're unaware of the risks of purchasing a home without representation. How would you feel if you closed on the home and then you found out the home had a problem that the seller was not aware of, and so it wasn't disclosed to you, but maybe with proper representation, you could have discovered that problem? Because without representation, if there's a defect to the home that either the seller or the agent, the listing agent, is unaware of, there's going to be no ability to disclose that to you. But with an agent, they're going to assist you in all of the investigations, and there are many. You could take out a purchase agreement and show them all the different things that they can investigate. When approached by an unrepresented buyer, consider dual agency, because what you want to do, perhaps, is convince the buyer to gain representation, to acquire representation. And some agent's going to say, so you need to go find an agent. That would not be my style. But some agents don't want to work with the buyer, but then you could refer it. So you could refer to another RE/MAX agent. It's still dual agency, but you would be working with the seller, and you would refer this buyer to somebody who will work exclusively with you. See, make sure you understand the difference between representation and works with. So never ever tell a buyer who is represented by a RE/MAX agent, RE/MAX Connections agent, that I only represent you, or tell a seller who is using a RE/MAX Connections agent to help buy the house, well, Mr. Seller, I only represent you. Tracy Denby, she represents the buyer. No. RE/MAX Connections represents both. So use the phrase works with. As your listing agent, I'll work with you. You could even say exclusively. I'll work with you exclusively. The buyer's agent, Tracy, will be working with the buyer. Make sure that's phrased. Versus pure dual agency. Now, some of you, and it's not illegal, by the way. And so since it's not illegal, we as a brokerage do not prohibit it. We do want you to be cautioned, be careful rather, when you're a dual agent. That's part of the reason for this class. I want to walk you through a few things. But pure dual agency, and I'm using the word pure there myself, is when the same agent is working with both the buyer and the seller. I am going to be the buyer's agent. I am going to be the seller's agent. Okay, listing agent. When approached by an unrepresented buyer, first, advise the buyer they should have representation. And second of all, offer representation if you choose to. Now the offering could be you're going to represent them, or let me refer you to another agent in the company, because I would be disappointed if you said, let me refer you to a Century 21 agent. That would be problematic. If any seller says, I will not tolerate dual agency, you need to call me. because we can't represent somebody. That means 145 agents can't work with any buyer who might be interested in purchasing that property, and that would be very problematic. Okay. Pure dual agency. Let's look a little bit at that, or refer to another RE/MAX agent, still dual agency. We're going to talk a little bit about that. If the buyer wants to proceed without representation, follow the procedure agreed to with the seller. So you offer representation and they say, no, thank you. Well, now you've already discussed it with the seller. Okay, I understand, but here's your problem. The seller does not want to entertain offers from an unrepresented buyer. You're welcome to submit one. I'm legally obligated to provide, to present all offers prepared, but I'm just telling you in advance, be prepared for the seller to reject it for no other reason. You don't have representation. Seller will not entertain offers from an unrepresented buyer, or proceed with facilitating the offer from an unrepresented buyer, because you are being compensated for it. The listing agreement, paragraph 2C2. All right, that's the second paragraph. And again, that's not for representing the buyer. If you're going to represent the buyer, the seller says, oh, no, if you want to represent the buyer, I don't have a problem with that. Well, that's good because, you've already agreed to dual agency. And I'm going to not only, work with the buyer, I'm going to represent the buyer, represent you too. I'm going to be a dual agent. No, that's fine. That's fine. Well, that's not what the 2C2 is. The buyer would pay you as the buyer's agent based on the BRBC. The seller would pay you as the seller's agent based on the RLA. 2C2 is there is no agent involved on the buyer's side. And so you're doing all that extra work I talked about earlier. Providing forms with unrepresented buyers. A lot of discussion about this. I want to cover this a little bit more in a little more detail, or get it in a presentation so you got it, you can review it. First of all, use the BNA. Make sure that when you provide forms to the buyer, you start with the BNA, Buyer's Non-Agency Advisory, or I think agreement, actually. It's not an advisory, Buyer's Non-Agency Agreement. Make a written statement, not just verbal, but in writing. An email is fine. The following points. I do not represent you. Providing forms at the request of the seller to facilitate the sale. You're giving them an offer to purchase, maybe even helping them fill it out at the request of the seller, because the seller has said, no, I'll work with unrepresented buyers. I want you to sell my home. Well, I would argue you tell the buyer, go on the internet, good luck. You're going to get a lot of garbage. So you can provide it perfectly legal. It does not create agency by itself. And by doing these things, it establishes that just because I gave you a form doesn't make me an agent. You're actually denying agency as a part of this. The BNA, then a written statement, I do not represent you. I'm providing the forms at the request of the seller to facilitate the sale, and I recommend you obtain your own representation. You make those 3 points. I didn't number them, but there they are, 1, 2, 3. And you repeat that statement, those 3 points, with every contact with the buyer, every time, every email. It's going to be, cut and pasted, every email. I do not represent you. I'm providing you maybe an answer to a question. I'm providing you an answer to the question at the request of the seller. And I recommend you obtain your own representation. Yeah, the seller told me the roof is 10 years old. As opposed to an email saying the roof is 10 years old. Because why? Because this redundancy will make it almost ironclad that you are not the buyer's agent and you have not assumed agency unintentionally. So very important you do that. Okay, if the buyer submits a non-CAR form offer, my recommendation is you use CAR forms. We are insured if we use CAR forms. Not so much if we don't use CAR forms. So you can counter buyer to submit offer on CAR form. That's a perfectly legal counter. Attach a blank form. Make those 3 statements I just covered. Make sure on your form you put the property address and your name as a listing agent. There's been a lot of discussion. Well, buyers will copy it and use it for other things. Well, that's true. Buyers will also speed, and some buyers will be dumb enough to drink and drive. I can't help that. I'm going to be careful. I'm not going to be driving around at 2 in the morning. I'm old enough to stay home at 2 in the morning because that's when all the drunks are on the road. I'm going to be careful that I make those 3 statements when I provide the form. Do they take the form and white out the address, white out your name, and give it to another seller on another property? Yeah. But the very fact they do that will make it even harder for them to make a claim. You gave them the form, so therefore you are their agent. That is not going to happen. So, I mean, they could make the claim. We're going to defend it. And I would submit successfully. Okay, now let's talk about dual agency and fiduciary duty. These are in the cases where you are willing to represent the buyer, or, as I said earlier, we're referring it to another agent in the company, and they're getting their representation from RE/MAX Connections. Okay, so the first thing is I want you to know that real estate agents are required to provide an agency disclosure, not telling you anything you don't know, explaining an agent's obligations to buyers and to sellers before confirming agency. That's the first form on every contract when you print it out. Okay, you confirm the agent's agency relationship in any real estate purchase contract. Agency is determined by the brokerage, not the agent. I think most of you know that. I just need to make it. Oh, no. I only represent the seller. Tracy represents the buyer. No. You represent the seller and the buyer. Tracy represents the seller and the buyer. It is dual agency because agency is specific to the brokerage. There is some research Car Legal is doing with the legislature to try to tweak that a little bit. Because they actually believe dual agency is going to kick up. By the way, dual agency is illegal in some states. I think Carr is accurate when they say this is an attorney at Car Legal that likes to say dual agency will never be outlawed in California. The California Trial Lawyer Association would never permit that. That's where they get their fodder for lawsuits. So it's allowed, it exists. It'll probably continue to exist. It's determined by the brokerage. When a brokerage firm represents both the buyer and the seller, then all agents in the brokerage firm are dual agents. When both the buyer's agent and seller's agent work for the same brokerage, dual agency is created at that point and must be disclosed and agreed to by the principal. The civil code requires that the principals agree to dual agency. That's why it's on the property or more than representation of more than one buyer and seller form. That's why that's required up front, because that gives us authority to be dual agents. The purpose of the AD is to educate the principals as to the duties and responsibilities of a listing agent, a buyer's agent, and a dual agent. Civil code requires that. You must give that to them before you confirm agency. You cannot give it to them after. Well, you can, but you would have a problem if that got part of a lawsuit. So before you confirm agency, you can do that confirming agency on an RPA, or you can do a CA, confirm agent AC, I think rather, agency confirmation. Civil code does not require an agent to give an AD to an unrepresented buyer. However, an agent working with an unrepresented buyer should give an AD because it is part of the BNA. It's referenced in the BNA. The BNA requires delivery of the AD to the unrepresented buyer. So in general, give everybody an AD if you're going to do any paperwork on the transaction. Now, you give them to your clients and to unrepresented principals. You don't have to give an AD to the other agent's client. That's no longer required. Now, regarding confirmation of agency, civil code requires that the agent confirmation include, and Lindsay checks on this, and every once in a while people complain a little bit, we're being picky, what big deal. No, it's in the civil code. The brokerage name and license number, it's got to be there. Your name and license number. By the way, they're not the same number. And the license number is not Mike's license number. Mike is a licensed broker. That's a fact. But the RE/MAX Connections also has a license. And so that's the license number. So civil code requires it. Most of you don't have too much of a problem with it. Sometimes you forget, and that's okay. We do an addendum, do a confirmation after escrow opens, getting that information in the record because the civil code requires it. And then the relationships, whether you represent the buyer, the seller, or both. Now, I believe Car Forms has fixed it so that if the same brokerage name is in both the buyer and the seller field, you cannot check exclusively buyer or exclusively seller. You can't do that. You have, both is the only one that will allow you to check. In the past, you could have the same brokerage, two different agent names, and then check buyer only for one agent and seller only for the other agent. And that's a mistake because agency is relative to the brokerage. The most common and critical mistake agents make with confirming agency is failure to disclose a dual agency, stating in some way that a dual agency doesn't exist when in fact it does. That's exactly what I just referenced. You check it. I don't think you can do that on RPA anymore. But if you can, don't do that. If a broker's a dual agent, you are a dual agent. It's as simple as that. Okay, now licensees' duties to all parties. In civil code, all licensees have duties to anybody, to everybody. By the way, a few times in the past, not nobody on this call, but a few times I've had attorneys challenge, a non-client attorney that does not represent our client, challenge me because they were alleging we failed to provide one of these duties. And they are in the civil code. You have to deal with any party in a transaction in a way that's not deceitful, fraudulent, or dishonest. You have to. One of your duties is to be honest. Isn't that nice? Common sense. We were taught that by our mothers and our dads. Hopefully, it's actually in the civil code. You have to be honest. You cannot tell a lie. You can, but you'll get in trouble for it. Exercise reasonable skill and care with respect to all parties in a transaction. You have to, provide reasonable skill and care even to your non-clients. Disclose to each party as soon as practicable any material relevant fact that you're aware of or should be aware of about the property, i.e. your disclosures, your AVID, and any compensation and its source that you receive. So if you're paid, your duty is to let everybody know you're being paid and who's paying you. Abide by all other duties and responsibilities that are in the civil code relative to real estate agents in particular. So you have a duty to all parties to follow DRE regulations. It's as simple as that. All right. Now, duties owed to your client. I'm going to give you some general duties that are listed in the civil code, and then I'm going to talk about fiduciary duty, which is also a separate section in the civil code. Okay, so you have to exercise reasonable skill and care to carry out the terms of the agreement you have with your client. You have a duty to do a good job, in other words. A violation of this, not returning phone calls could be a violation of this very duty you owe to your client. Because your client has a question, they're trying to figure something out, they need to know in order for them to proceed with the transaction, and you're ghosting them. That would be a violation of this duty. In addition, it would be a violation of your fiduciary duty as well. We'll talk about that in a minute. Not to disclose confidential information about a client unless you're required to by the court and the adjudicating authority. To seek a sale or purchase price that's acceptable to your client. You have a duty to sell the house at a price the client's happy with, or buy a house at a price the buyer's happy with. I mean, kind of common sense. Present all offers made or as soon as practicable unless the client chooses to waive that duty. So this is presenting offers to listing agents And to sellers rather, by listing agents. And if a seller doesn't want to see any more offers, they need to weigh that in writing. Or if a buyer writes an offer, you have a duty under the civil code to present that offer as quickly as possible. And disclose to any client material facts which the licensee has knowledge of about the transaction in general. So you'd have a duty if you found out that buyer's lost his job and now the loan may be a challenge. Well, I don't want to tell the seller. I don't want to upset the seller. You're just violating a duty you have to the seller because that's a material fact about this transaction. Advise the client to obtain advice from an expert regarding matters that you do not have expertise in. That's also a duty set out in the civil code. If you don't have expertise in whatever it is the client's asking you about, you have a duty to advise the client to seek out expert opinions. That's common. The common practice of that is we tell clients to get legal opinions all the time because we're not lawyers. We frequently tell clients to talk to their accountant all the time because we're not accountants. We often tell the client to talk to the physical inspector. Why? Because we're not physical inspector experts. We're not the physical features of the home. We're not experts on, what this means that the tankless water heater isn't, it doesn't seem to be coming on correctly. Well, we don't know anything about that. You need to talk to a plumber about what the implication of that is. And then account to the client for any money or property that is placed in your care. All right, now fiduciary duties. There are 6 that are spelled out in the civil code. A real estate agent or broker can be an agent for a buyer exclusively, a seller exclusively, or for both, either intentionally or through the execution of a written agreement. So, intentionally execute a written agreement. So the RLA spells out that you are the client of the buyer or the seller or both. The BRBC spells it out, or the SBRP, and so does the RPA. You can become an agent of a buyer, a seller, or both unintentionally through a course of conduct. And again, not to beat the dead horse, providing a form to the buyers often thought of as, oh, I'm unintentionally creating agency. You are not, especially if you take the precautions that I outlined a few minutes ago. Okay. Any real estate agent who becomes an agent for the buyer or the seller will be deemed a fiduciary. So if you are somebody's agent in real estate, you are a fiduciary and you have fiduciary duties to that client. Fiduciary duties are the highest duties known to law. Very, very, very important. And you'll be held under law to these specific duties to your client. You can be sued for violation of your fiduciary duties. These duties are in addition to any duties set forth in the listing contract, the buyer representation contract, or the purchase contract. So what are the fiduciary duties? I'm going to go through them quickly. Obedience. We'll talk about each one of these in detail. Loyalty, disclosure, confidentiality, accounting, and finally, reasonable care and diligence. All right, let's look at them one by one real quickly. So obedience, what does that mean? An agent is obligated to promptly and efficiently obey the lawful instructions of your principal. If your principal tells you to do something and it's lawful, you're obligated to do it. There is no obligation to obey an unlawful instruction. If they tell you to do something that's not lawful, sorry, can't do that. Advertise my rental property, no Section 8. Tenants. Nope, that's against the law. Can't do it. Sorry, won't do it. Don't show my house to any minorities. Nope, sorry, can't do that. I won't not do that. I will show it to anybody who's interested in buying your home. Compliance with any unlawful instruction could be a breach of your fiduciary duty of loyalty. I'll cover that in a minute. So if you do something that's illegal, maybe you're not violating the obedience duty, but you're violating the loyalty duty. You'll see that in a minute. Sort of a catch-22. So don't do anything illegal. All right. Duty of loyalty is the most fundamental of the fiduciary duties owed by a client. Courts will rank duties, and loyalty is the highest one. Loyalty is the client is putting their trust in you. It obligates the agent, to at all times act in the best interest of the client and to put the client's interest ahead of your interest. Every once in a while, an agent will tell me a problem, and their biggest concern is this falls out and they're going to lose their commission. The good news is that doesn't happen too often. Nobody on this call. But if you're focused on your commission rather than the problem, you're already on the road to violating your fiduciary duty of loyalty. You have to put the client's interest ahead of yours. A duty of loyalty also dictates that an agent avoid conflicts of interest that could compromise an agent's loyalty to his client. Disclosure. An agent's obligated to disclose to his client all relevant material information the agent knows about pertaining to the scope of agency. In other words, pertaining to the transaction where you're the agent of either the buyer or the seller or both. Disclosure. An agent who represents a seller must disclose to the seller all offers to purchase the seller's property, unless in writing they tell you not to. The identity of the potential purchasers and any fact affecting the value of the property. An agent who represents the seller must disclose to the seller all offers. Oh, another duplicate slide, I'm sorry. Information concerning the ability or willingness of the buyer to complete the sale or offer at a higher price, except in dual agency. So in other words, let me unpack that a little bit. If you do not represent the buyer, and the buyer happens to say to you, I really want this house, and if I got to pay full price, I will, but I'm going to try to get it for less. And you don't represent the buyer, you would have an obligation to tell the seller that. Now, if you represent the buyer, you would not, you were dual agent, you represent the buyer and the seller, you would not have an obligation to convey what a buyer might pay for a house. Broker's relationship to the prospective buyer or your interest in it. So if you're, your LLC, you're a member of the LLC that's buying the property, you need to disclose that. If the buyer's intending to resell the property for a profit and you as a listing agent are aware, but again, this would be a duty of an agent. And in this case, if the buyer intends to resell the property and you're the buyer's agent, well, you don't have to disclose to the buyer, hey, by the way, I just want you to be aware that you plan to resell this home. That'd be kind of ludicrous. But if you represent the seller and the buyer tells you they intend to resell the property, you would have to tell the seller that. Any information that might affect the seller's ability to obtain the highest price and the best terms for the sale of his property. An agent who represents the buyer must disclose to the buyer the willingness of the seller to accept the lower price, except in dual agency. So if so you're at Caravan and some, I say this with love, but idiot agent says, oh, my seller's really motivated. They're desperate to sell. Make us an offer. We're willing to negotiate. Well, you probably have to tell your buyer that, unless it's a dual agency. Now that shouldn't be discussed. But the willingness of the seller to maybe, sell at a lower price or has urgency, again, except in dual agency. As a buyer's agent, you have an obligation to convey that. See, the caveat would be you keep it a secret in order to have a higher price transaction, and then the law looks at you as trying to benefit from that because your commission will be higher. So that's sort of what the rationale behind all of this is so that you don't mislead a buyer or seller about what the transaction price could be, because that might be putting your interest ahead of their interest. But again, you would not disclose what a seller will accept or what a buyer would pay, except if it's in writing and you're a dual agent. So the seller says to you, I'll sell my home for less, but let's counter full price. You can't say, well, here's a full price offer, but by the way, the seller said you could probably counter that, come down a little. In dual agency, you can't share that information. broker's relationship or interest in the sale in the seller's property. So the fiduciary duty that a buyer's agent has to a buyer is if that buyer has an interest, you represent the buyer rather, and then you have an interest in the property that the buyer is buying. Any facts relating to the value of the property, the length of time the property has been on the market or any other counter offers that have been made. You have a duty to disclose that if you are aware of that. Some of these things you're not aware of, so you can't disclose what you don't know. Any other information that would affect the buyer's ability to obtain the property at the lowest price and the most favorable terms. An agent's duty to disclosure to his principal should not be confused with an agent's duty to non-principals to disclose material facts of the property. So whether you're the principal or not, you have to disclose to anybody your awareness of the condition of the property. Anybody who's involved in the transaction, obviously, not to somebody on the street. See, this duty to disclose known material facts is based upon an agent's duty to treat all persons honestly and fairly. That's part of violation of fiduciary duty. You knew something bad about the house and you didn't tell the buyer, even though you don't represent the buyer. All kinds of ways the law can, wrap their tentacles around you and get you in trouble if you don't do the right thing. This duty of honesty and fairness does not depend on the existence of an agency relationship. So I have to be honest to a buyer, period. I have to be honest to a seller, period. I have to disclose to a seller, period, if I have a knowledge that the buyer doesn't qualify for the loan they're trying to get. If I'm aware of that, the lender told me, no, he doesn't qualify. Well, I'm going to keep it a secret because maybe he'll win the lottery. You can't do that. I have to disclose, yeah, there's a problem with the garage door opener. It keeps shorting out. Yeah, I got to disclose that. I mean, it doesn't matter whether I represent the buyer or not. I have to disclose it. Confidentiality. An agent's obligated to safeguard your client's confidence and secrets. Keep everything confidential that might weaken the client's bargaining position unless you have written permission. An agent who represents a seller, including dual agent, cannot reveal a seller's willingness to accept a price less than list price. See, so you represent the seller, you can't pass on that the seller will accept a lower price. When you represent the buyer, you cannot pass on that the buyer will pay a higher price. Confidentiality does not include any obligation that the broker that's representing a seller to withhold from the buyer material facts. So, Walt, I'm going to tell you something in confidence. My toilet, there are roots in the drain line of my toilet. We had them rotor-rooted 2 or 3 times in the last year. They keep growing back, but it's working now. Don't tell the buyer. I mean, as ludicrous as that sounds, I make it kind of ludicrous, but there have been other cases where sellers have told sellers agents not to tell buyers something that's a material fact, and while I didn't want to violate the confidentiality of my client, they told me that in secret. No, it's a material fact. You have to disclose it. It would constitute misrepresentation and impose a liability on you and possibly the seller for hiding something. Now, this is important to know. The duty of confidentiality does not terminate with the escrow. It lasts indefinitely. So, close a year ago and the buyer wants the seller's phone number. You cannot give that out. That's confidential. Any information that would be confidential during a transaction is confidential after a transaction as well. Keep that in mind. Yeah, if you have anybody pursuing, they want information, contact me. When our own client wants paperwork, I don't have a problem giving it. When the other side wants paperwork, if they were entitled to the paperwork during the transaction, then we don't have a problem giving it. But if they're asking for something they weren't entitled to during the transaction, then the confidentiality principle kicks in, and we would require a court order to provide that. Now, I don't need you to get in the weeds there. If you're being asked to give stuff after close of escrow, and you have any question at all, contact me. All right, accounting. You're obligated to account for all money and property that are entrusted to you. And property includes documents. So if you're provided documents, you have to take care of. Sometimes it scares the heck out of me. The only copy of the trust, the agent's carrying it around to make photocopies to send the title company. Well, keep in mind that that's you're being entrusted with that. You have to make sure you give that back to the seller or the buyer, whoever's trusted it. Reasonable care and diligence. An agent's obligated to use reasonable care and diligence pursuing his client's objectives, and the standard of care expected of an agent is that of a competent real estate agent. Well, he's brand new is not going to be a defense. Well, this is only a second transaction. That will not be a defense. By virtue of your license, you are deemed to have the skill and expertise superior to a layman. You are a licensed agent. You're supposed to have the ability to do the transaction, theoretically, from a legal standpoint, just as well as someone who's been licensed for 30 years. An agent is under a duty to use your superior skill and knowledge to effectively pursue the client's objectives. Duty includes an obligation to discover facts and matters of concern relating to the client's affairs and objectives. So you got to ask questions. What about this? What about that? Of your clients. It's pretty straightforward. What is a dual agent? Dual agency when the same brokerage represents both the buyer and the seller. You walk a very narrow path to be neutral toward both parties. I can't disclose anything of a confidential nature to either party. You have to be very careful because you may be entrusted with information that you can't share with your own client because it's a confidential bit of information from your other client. Dual agency is one real estate agent representing both the buyer and the seller. One agent or broker. Dual agency is legal. It is tightly controlled and regulated. You can get in trouble if you're not very careful as a dual agent. A buyer or seller can refuse dual agency, by the way. That's and some buyers and sellers will. If a seller refuses dual agency, you need to contact me because that makes it very, very difficult for the other agents in the company to sell, possibly sell that property. Dual agency occurs when a listing agent and a buyer's agent are the same entity, and the entity can be either one agent representing the buyer and seller or two agents from the same brokerage, one representing the buyer and one representing the seller. It is still dual agency, sort of beating a dead horse, but I want you to really, really internalize this. It's legal in California, but regulated to protect buyers and sellers from predatory practices. California Civil Code requires both the buyer and seller to consent to being represented by one brokerage. It can cause legal issues because fiduciary duties that bind real estate agents. These duties require undivided loyalty to their clients, and a buyer's agent must act in a buyer's best interest, a seller's agent must act in a seller's best interest, and it can get a little problematic. A single person acting as a dual agent would require loyalty to both sides of the negotiating table, and at best, that's a tricky task. So keep that in mind. Get guidance. I'm going to tell you the most common mistake agents make here in a minute as dual agents. You have fiduciary duties are written in the civil code, in the tort, and in the licensing laws. So you've got to be very careful. You have to disclose dual agency, and all parties must give full permission to proceed. It represents unique concerns and problems. It can be balanced somewhat by a few advantages. With one fewer agent in the mix, scheduling various events can be more manageable. The transaction can move a little smoother. Dual agency relationship with transaction can speed up some response times. The other agent may not be the smartest agent, but I know when I call him, he'll answer the phone because the other agent's me. So, it can help in some ways. You can answer questions without waiting for the other party to respond. So a dual agent can sometimes aid in negotiation. It can be a problem, but it can also be helpful. It does sometimes streamline the process. So it's not all negative. A dual agent can't negotiate to get the seller the highest price while getting the lowest price for the buyer. Advocating for one client at the expense of the other is virtually impossible. And there are no fresh eyes in dual agency. You know, you don't have another agent looking at it and oh, what's this? Oh, gee, I don't know. We need to check on that. That can be very helpful. Now, this is important. This is most common violation of dual agency. A dual agent cannot initiate a process for one client at the expense of the other client. Doesn't mean you can't facilitate the process. You simply can't initiate it. So what does that mean? So it's time for the buyer to remove his contingencies, and he's still got a problem with his loan. You cannot call the seller up and say, we need to give the buyer a notice to perform to remove his contingencies. You can't do that. You can say, you can't call the seller up and say that. You can call the seller up and say, the contingency time window is up. If you, seller, want the buyer to remove contingencies and you want me to pursue that, please send me an instruction to prepare a notice to perform. Now, when you're a single agent, you don't go to that much trouble. You just call up the seller and you say, look, they haven't removed their contingency yet. You know, I'm going to send you a notice to perform. You sign it, we'll send it to the buyer. So you're representing the best interest of the seller. Why? Because you're the seller's interest. When you're a dual agent, you doing that is at the detriment to the buyer. You can't start a process at the expense of the other. But it doesn't mean you sit there like a bump in the log. Gee, I don't know what we're going to do. I'm a dual agent. No, you can explain to the seller, you have contractual rights. If you want the buyer to remove contingencies, you have in the contract the right to ask me to give them a notice to perform. And you can do the same thing to the buyer. Look, the seller does have a right to give you a notice to perform. You want to be prepared for that if the seller instructs me to do that. You can't say to the buyer, I'm going to give you a notice to perform. You got to remove those contingencies. I actually had an agent one time, classic story. It's a quick one. They were explaining to me a very complicated process. He was a dual agent, and he made the following statement. Well, Walt, the seller is my real client. Oh, no. Both clients are your real client. So don't think about, as, and that's a problem because usually you're more loyal to one client than the other. You tend to be that way because you know one client better than the other. You represent the seller, and here comes the buyer wants you to write an offer. You've been working with this buyer for years, and they found a house that we happen to also have the listing, and the buyer wants you to write that offer. You end up falling into a dual agency, but you often have a closer relationship with one principal. You've got to sort of move to the neutral field there right away. All right. When you're acting on behalf of one party, you're called a single agent. Loyalty is easy. When you're acting on behalf of both parties, you're a dual agent, and loyalty is much more challenging and problematic. All right, handle the seller concessions real quickly, and we'll get through this in just less than 5 minutes, not even that. Okay, seller concessions. Seller concessions, as you all know, seller credits are a payment to the buyer to convey any expenses. In other words, part of the buyer's closing costs, which could include the buyer agent compensation, obviously. Seller concessions can be used by the buyer to pay the obligation to pay his agent. When considering seller concessions, I want you to think of two separate and distinct scenarios. One is offering them, and the other is agreeing to them. Those are two separate and unique scenarios to be thinking about when you're having seller concession discussions. So a seller's offer to pay concessions to a buyer should not be designated to pay the buyer's agent's compensation. So when you're offering to pay concessions, you should not say, yeah, the seller will give you concessions to pay your agent. You should drop off that to pay your agent. That should leave your vocabulary completely. You should not specify to be used to pay buyer's agent in conversations, emails, marketing pieces, and especially in the MLS. It won't be allowed. And if you somehow slip it into the MLS, you will be fined. A seller's agreement to pay concessions is in the RPA. And it can be designated to pay the buyer's agent's compensation. Paragraph RPA 3G3. And the reason you can designate it for the buyer compensation is that concession won't count against other credits, the cap to other credits the seller might give the buyer. So in the RPA, you can definitely designate it as payment to the buyer's agent. That's in the agreement, not in the offer. By offer, the offering of it. Okay. An offer to pay concessions is exactly that. It's an offer. It is not a commitment, it's not binding. I would argue calling up a listing agent saying, is your seller going to pay concessions is probably a useless exercise. Because they say yes, there's no obligation, it's not binding. Until it's part of the RPA, it means nothing. You know, you can get in trouble either way. I was talking to an agent yesterday. The problem with calling every listing agent, because your seller wants the seller, your buyer rather wants the seller to pay concessions. So you're calling all the listing agents, and the listing agent says, yeah. And so the buyer says, great, let's put an offer together. And then the seller decides not to pay it. Your buyer is going to be mad. Well, you told me the seller would pay it. So you want to make it clear that it's not binding. The fact that the seller says he'll pay concessions is, in an email, in an advertising piece. There's no teeth behind it. So why even bother asking? If you like the house, you want the seller to pay it, put it in the offer. If they don't like it, they'll counter it out. Maybe you'll have to, sweeten up the deal in some way to get them to pay it. An agreement to pay concessions is exactly that, an agreement. It contained in the contract that's signed by the buyer and the seller and is binding. This slide here, burn this slide into your brain regarding concessions and how you deal with them. Offers are not binding, agreements are. Seller's offer to pay concessions should not be specific to percentage or dollar amount. You cannot specify a percentage or a dollar amount in the MLS, and you shouldn't do that. Think of it, a seller's agreement to pay concessions must be specific in an agreement, a seller's agreement. See, not a seller's offer. The offer should not contain how much they're going to pay. That's kind of, price fixing. That's kind of, anti-competitive practices. A seller's agreement needs to be, if I'm agreeing to pay the buyer's agent, it's got to be a specific amount. It's in the SPBB. When marketing the seller's offer to pay concessions in the MLS, have the seller authorize this in the MLSA paragraph 5B2. That's where the seller gives you permission to advertise, including in the MLS, that the seller will consider paying concessions. And the phrase we use, you can write this down if you want, it's right in the MLSA paragraph 5B. Both 1 and 2 contains the exact same phrase. Seller is willing to consider offers asking for concessions. And you can put that phrase in private remarks. Don't put anything else. Do not mention commission. Do not mention a specific amount. Very important not to mention buyers, agents, compensation, and commission in the MLS. It will result in a hefty fine, $1,500. There have already been fines in other MLSs. Have already confirmed that agents are being fined upwards to $1,000. I've been told specifically by agents, by brokers. My agent got a $1,000 fine yesterday. CRMLS, $2,500 fine. And there is no warning and there's zero tolerance. One of the reasons I want to do this and the reason you're sticking around for the extra 15 minutes is I want you to hear this. Don't want you to be giving your money up because you meant well. Seller will offer concession, a buyer can use it to pay their agent if they choose. What's wrong with that? It's against the rules, you'll be fined. Simple as that. Listing agent, when discussing to a potential seller concessions with a buyer's agent, should not specify a percent or a dollar amount. Back to what I said. When you get calls from buyers, will your seller pay a concession? Well, the sellers, authorize me to tell you that they'll consider offers with concessions. Well, how much are they paying? Well, put it in your offer. It's negotiable. See, think about it this way. What would you say if a buyer's agent called you up and before presenting an offer said, will your seller reduce his price by $2,500? Yeah, he will. Well, you can't do that. You wouldn't do that. Don't do that with concessions because, he'll pay 3%. The buyer only wants 2%. Oh, let's change the BRBC to 3. Let's get that extra percent. See, that's what would happen. You don't want to do that. If the seller insists that you provide a specific seller concession amount, have the seller communicate that to you in writing, i.e. an email. but you will not be able to put that specific amount in the MLS. Keep that in mind. All right, some final thoughts. We'll wrap it up. Situation regarding buyer representation is going to evolve. This is a work in progress. Hopefully, the cost of buyer representation, buyer paying buyer's agent, will be financed in the future. There's movement to that. It's already, in some ways, already kind of happening in the way, you're building it into the price. They're not counting it against other concessions. Lending industry is open to that. That'll evolve. Biggest thing that these lawsuits and our settlement have caused is the need for agents to have conversations with buyers and sellers about representation and commission. This has often not been done to the detail it must be done now. And how representation is paid for. That's critical going forward. Buyers can have representation, and agents, you have to rise to the challenge to find out ways for it to be paid for. The immediate challenge, having buyers sign representation agreements. That's what's in front of you now. You want to develop your skill at getting buyers to sign some sort of representation agreement, and how you structure that agreement in a buyer-friendly way that meets your business standards. So understand the changes. And you're on this call, I'm preaching to the choir. Know the new rules. You're on this call, I'm preaching to the choir. Know the forms. Again, you've been on calls, I'm preaching to the choir. Know all of the new practice changes. Now, if you have any questions, reach out. We're here to help. And finally, folks, take care. That's it. Hope that was helpful. Sorry, ran a little long. Wanted to get through this. Lindsay, do we have questions?
Yes. Oh, did someone want to go?
Yeah, I have a question. This is Azim.
Okay.
Yeah, I spoke to you a while ago on the listing agreement. The seller agrees on paragraph C2, additional compensation to the seller broker if buyer is unrepresented.
Right.
In my case, seller agreed to pay 2% compensation if it's the buyer is unrepresented.
Additional compensation.
Additional. So if the buyer comes to me as a listing agent, say I'm unrepresented, can you ask the buyer if they are okay to have a dual agency relation?
Yeah.
Convert
part of my presentation.
convert them to the dual agency situation.
I'm sorry?
I said convert them to be, as a dual
well,
agency.
if you're going to represent them, or if the broker's
Right.
going to represent them,
Okay.
you need representation. We can function as your agent. Of course, we'll be dual agency, but if you're comfortable with me having, to work with both, don't use the word represent. See, are you comfortable with me representing? Use the word work with. If you're not comfortable with me working with you, I can refer you to another agent in the company. All right. So yeah, you can do that.
Yeah. All right.
Can I answer the question?
Great. That's it.
Okay, Lindsay.
So the listing agent must show their listing to an unrepresented buyer without the buyer being required to sign a BRBC?
The listing agent must show their listing to an unrepresented buyer without the buyer. Well, yeah, I mean, if the way that question is phrased, I'm not sure if I'm answering it correctly, but you are allowed to show your listing to a buyer who has not signed a buyer representation agreement. Yes. Did that answer the question?
Gene? He can chime in if he wants.
Okay, all right.
Can we enter in?
Yeah, that was my question.
Yeah, you're showing the property because it's your listing, and the brokerage owns all the listings. So, one could argue, if we had to, I mean, I would prefer that if, Gene, it wasn't your listing, it was, Pete Hagen's listing, I would prefer that you get a representation agreement. But if you are having difficulty getting one, I would still be able to defend you, because that's a broker listing, and you, as an agent of the seller, even though you weren't the person at the listing presentation, are showing that listing to facilitate our obligation to the seller to sell that home. So yeah, you can show property that are our listings to buyers that have not signed a representation agreement.
But that's not considered dual agency then. because they're not represented.
Well, if
They're-
they're not represented, it's not dual agency, right? But, you know, showing a property does not create agency. The fact that you show property does not necessarily create agency.
Okay, well, that's,
Great. I tell you what, okay, let me expand on a little bit. Here's what creates agency. They're asking you a ton of questions about the value of the property, what's the neighborhood like, what's the appreciation rate of I mean, when they're doing the kinds of things that buyers would talk to their agent about. You're not their agent, but you're giving them all this information. You're starting to bleed into unintentional agency because you're advising them. Giving a buyer advice that, you know, it can lead you into unintentional agency. So if you're showing a property and you don't have an agency agreement to a buyer, it's got to be kind of cold. You know, it's got to be kind of, here's the house. How old's the roof? Seller said it's 10 years old. I mean, I could answer factual questions, you know. What do we do if we're concerned about the roof? Can we ask a seller to get an inspection? And then you say, well, what's your concern about the roof? If you start handling them like they're a buyer client, you're creating a client relationship. So showing a house by itself, handing a form by itself does not create agency. Guiding a buyer begins to lead into that.
yeah, that's a new one to me. You're saying now that we can show other agents listings in the brokerage and you don't have to have a BRBC.
No, that's not what I said. I said I would prefer not, listing contracts are specific to the broker. Can you hold an open house on Pete Hagen? And for those of you who don't know, Pete Hagen's another agent in the same office that Dean's in. Could you hold Pete Hagen's listing open? Of course you could. So you do an open house on Sunday. Could you walk a buyer through that house without a buyer agency agreement? Yes. Why? Because you're doing it as the listing agent. You know, you're not the listing agent that sat at the listing presentation and took the listing. However, if you're going to start doing a lot of that, you know, I would get a buyer representation agreement because you starting to get in a little bit of a gray area. That question has been asked of the attorneys who are specializing in NAR settlement procedures, and their answer is the same. You can show your own listings, absolutely. Could you show a brokerage listing? Yeah, I suppose. But if you make it a habit to show a buyer 25 listings that are all our listings, you're probably working for the buyer. See, you weren't just facilitating the seller, you know, yeah, show this listing. You're actually trying to get this buyer to work with you. Well, then get a BRBC. Does that make sense? If
Yeah.
not, call me.
I don't like it, but it makes sense, I guess.
Well, you don't have to like this stuff, but I would lean into it because it's the way of the future.
Can we enter into the MLS that the seller will not entertain offers from unrepresented buyers in the general remarks or the confidential remarks?
That's a great question. Unrepresented buyers. I'd like to make sure that we don't. I'm going to get an answer to that for you. We're going to check with the two MLSs. I think in principle you probably could, but I'd hate to say yes and then there's some glitch, you know, some catch-22 and they're going to fine you $1,500. So Lindsay, make a note of that question, and we'll research that, and then we'll put out Agent Hub announcement. Whoever asked that question, that's a great question.
Okay.
And my only concern is my answer could cost you $2,500 if I didn't think of something that I should have thought of. I don't want to be responsible for that.
All right, there's a two-part question. What's the percentage of represented versus unrepresented buyers?
I don't know that number. I can tell you in the past, it was pretty rare based upon the questions I would get. I do think everybody who I have any respect for that I'm listening to, they believe that percentage will go up for the reasons I outlined.
And do you know any buyers that have paid their agent compensation since the changes?
I don't know of any escrows that's closed where we've actually had the buyer collect money.
Yeah, me neither.
It's so new. Yeah, you're
Yeah.
not aware of it either. Yeah.
If an unrepresented buyer still wants to submit an offer and the seller has said no unrepresented buyers, are we obligated to use car forms?
No, no. In fact, I would, see, here's and that's a great question in the sense that you got to always keep in mind your duty to the seller. So if the seller says no unrepresented buyers, period, then withholding a car form from a buyer who refuses representation is not acting against the best interest of your seller. See, if the seller said to you, I don't care, I can look at offers of unrepresented buyers, but you don't want to give a car form because you think there's too much liability in it, it could be a violation of fiduciary duty. Why? Because you're putting your interest. I'm not saying you're wrong. I wouldn't want to give out forms. I wouldn't want to worry about that liability. I agree with as I've said, I don't think you have a lot of liability. In fact, probably none. You do it right. But see, you're not doing it because you don't want to do it, because the seller didn't say, no, don't do it. But the minute the seller says, I do not want offers from an unrepresented buyer, you memorialize that, you have an email or something to make that clear. And then the next time a buyer says, send me a form, I'm going to go unrepresented. I'm sorry, the seller is not entertaining offers from buyers unrepresented. Well, I don't care. I still want to make an offer. Well, you can, but I'm not going to provide you a form. You can say that because the seller already told you to do that. By the way, you get an offer from an unrepresented buyer, you still have to present it or have in writing from the seller, do not present it. And you have to be specific to each offer. So the seller can make a general statement for marketing purposes, for procedures that you follow. But here comes an offer, unrepresented buyer. Well, seller already told me at the listing appointment, didn't want any of them. You would remind the seller of that and say, I have this offer. Do you want to see it? You have an obligation to present all offers. Hope that didn't confuse anybody.
This question kind of goes along with that. My
Okay.
seller does not want to work with unrepresented buyers, and Stacy had them send her an email stating that.
Yeah.
Will that suffice?
Stacy had them send.
An email stating they don't want to work with unrepresented buyers.
Yeah, that's that's an instruction.
Okay, with
Tell
that
them to tell.
said, would she have to show property to an unrepresented buyer? Will she have to show that property to an unrepresented buyer?
Yeah, I would err to the side of caution, because if they like the property, they can go get representation. See, if the seller said, I don't even want you showing property to an unrepresented buyer, I think you'd have a duty to say, what if they liked your house and wanted to buy it and were willing to get representation? See, remember, part of being, this is a capital S salesman. Look at my hand here, make a big S on the screen. Helping people make decisions they might not make without you, and they thank you for later. So my salesman hat, not salesman like make money, get commissions, but my helping people, I love sales when you approach it from helping people make good decisions. That's what good salespeople do. Okay, you don't want me to even show it to unrepresented buyer, but Mr. Seller, what happens if the buyer falls in love with it and is willing to get representation? Are you saying you don't even want, you don't want that opportunity? I'd be surprised if seller didn't agree with you. So showing the property, I would err to the side of showing it as much as you can. And there's another caveat there. It's a lot easier for a buyer who are refusing to show the property to make some sort of protected class claim. Yeah, you got this email, but I'm the wrong ethnicity. I'm the wrong religion. My sexual orientation is wrong, whatever. There are 22 protected classes, and the 22nd protected class is general. Anybody that might be protected or discriminated against because of some unique, it's everybody, So yeah, show property in general, you should err in that direction. But you don't present offers if the seller says no, and certainly the seller can respond rejecting it because it came from an unrepresented buyer.
Unrepresented buyers could be a protected class.
Well, they're not as a delineated class. There's no class called unrepresented buyer, but an unrepresented buyer could easily fall into one of those 22 categories.
Is it considered dual agency if I have a listing and the buyer uses another RE/MAX office?
When you say another RE/MAX office, you mean another RE/MAX Connections office? Yes. If you mean Remax by the Sea, which I don't think exists anymore, you mean Remax Lemon Grove, which is not their title, but Remax Associates, I think they still exist. Yeah, no, that's not dual agency. Agency is relative to the broker's license. So
Can
we
a,
have 4 brick and mortar offices and 1 virtual office.
can a seller require that an unrepresented buyer obtain a home inspection?
Oh, yes, absolutely. In fact, if you sell your own property, that is a requirement. Those of you that are flippers and investors, you know that in order to have in the maximum benefit of our E&O, we have a endorsement. Most E&Os, by the way, preach a little bit to the choir here and plug your management team, including Mike, who pays for it. Most E&Os do not insure agent-owned transactions. Most E&O companies do not insure flips. They simply don't do it because we have a lot of agents that sell their own properties, and we have a lot of agents that participate in flips from the get-go with Mike's blessing. Didn't have to convince Mike of this. But I informed Mike, we're going to have to buy, endorse, and pay, because you pay for it. We're going to have to find insurance companies that include it, and then we pay a little extra premium to allow us to do that. Now, my point being, with that endorsement comes certain rules. And one of the rules is if an agent sells their own or a relative's property, we require the buyer to get a physical inspection. And so we put that in the contract. So those of you who have done that before, there's an agent hub tab selling your own or a relative's property, and it has a memo telling you what to do and the specific forms that you need to use to satisfy our E&O company. So yeah, so a seller, whether you own the property or not, you could list your next door neighbor's house, and you could say to the seller, physical inspections are a good idea. And if you want, we can require every buyer to get a physical inspection. That's perfectly legal. And I've known agents to do that.
If you are the listing agent and another connections agent is working with the buyer, are you saying that the listing agent cannot advise or initiate the seller to send the buyer a notice to perform or
That's
remove
correct.
contingencies if it's time to do so?
That's correct. No, well, I answered that too quickly because the way the question was worded, it's a little, you got to be very specific. You cannot initiate the action of the notice to perform. You can tell the seller, today is the 17th day. Or if you understand how the contract works, you could say today's the 15th day. You're allowed to give a seller a notice to perform 2 days before the deadline. The deadline's 17th day. Today's the 15th day. See, that's the key. The dialogue is what's important. If you want the buyer to remove these contingencies, please advise me to give a notice to perform to the other agent. But you can't call the buyer up and say, we need to give the buyer a notice to perform. Today's the 15th day. So you're initiating the action. It didn't come from the seller. Now, it doesn't mean you sit around and wait for the seller to figure it out, because you represent the seller as well. So at any time you can say to the seller, oh, by the way, close of escrow is a week from now. Are you packing? So you could tell the seller what's in the contract and tell the seller what they can do. You can stay in this house 3 days after close of escrow, but not longer. If it's going to take you longer than a week and a half to pack, you might be running out of time. See, that's advising the seller. But you don't call the mover up unless the seller says, would you call the mover or the packing company? So I don't know if that analogy works, but it kind of does in my mind. You can call the seller up and say, contingencies are due to be removed on the 17th day. That's a factual statement. You're not initiating an adverse action. It's in the contract. If you want those contingencies removed, you have the right to give a notice to perform, and you do that through your agents. I do that for you. Here's the caveat. You want that email. Because if the buyer, we've actually had buyers over the years talk to attorneys, and they're pretty sophisticated. Your agent really was closer to the listing agent than they were to me, and they're my agent, and they sent me notice to perform. And I've had attorneys call me and say, please document that the seller wanted that notice to perform. See, so happy to do it. Here's a copy of the email. Mr. Agent, please provide the buyer a notice to perform. As opposed to the agent just prepared one and sent it. Why'd you do that? Because time's up. Buyer should remove contingencies. Well, did the seller ask you to do that? Well, it's in the contract. That kind of dialogue would get you in trouble as a dual agent. Wouldn't get you in trouble as a single agent. They wouldn't even complain, But as a dual agent, the key word is initiating the actual action. Get the seller to tell you to initiate it. You're off the hook. Hopefully that's kind of clear. If it's not, somebody raise your hand, Lindsay, put something in the chat, or call me if you're confused, because that is a very good point to focus on. And that is, as a dual agent, make sure that you're doing what you do that hurts the other side, because your side, if you will, the side that you're working with, wants it done. Well, you can do that, but they need to tell you to do it. You can tell them they have the right to tell you to do that. You just can't do it without them directing you to do it.
It's my understanding that compensation may not be mentioned or asked for in the RPA or counteroffers. Is that correct?
That's completely incorrect. Compensation in the RPA, that's what the SPBB is all about. That's what paragraph 3G3 is all about. Seller shall pay buyer's obligation to buyer's agent per attached SPBB. It can be in the offer for sure. I'm not sure, whoever asked that question, I'm not sure what you're thinking. I think I'm not understanding the question, because you absolutely, can. And in fact, the reason, as I said before, the reason there's a 3G1 and a 3G3 is because lenders have said that part of the concessions a seller pays to a buyer to cover the buyer's agent won't count against the cap on concessions that a seller is allowed to pay the buyer, period. So if the loan program allows a cap of 3%, third-party contributions, that's what they call it. So a third-party contribution, which is the seller's contribution, is capped at 3%, and the buyer's agent's compensation is 3%, and you put that compensation in 3G1, you're going to have a problem, because if you have a repair that you want to get a credit instead of doing the work, you got no more room. You've used all 3% up on the compensation. So you put it in 3G2, pay my buyer 3%. And later, when you do a repair request, you've got 3% available for credits for the repairs. So you definitely specify it in the RPA. You just don't specify it in the MLS for sure, and you shouldn't specify it in other avenues, or venues rather, I'm sorry.
To confirm, if we signed a listing agreement prior to August 17th, we can disclose to the buyer's agent the amount that was put into the original, I think he means RLA, if they call.
No, I wouldn't do that. Because there is no longer any contractual obligation for the seller to pay the buyer's agent. To the old RLA, that obligation existed in the contract because it could be enforced through the MLS. That's gone. So, I mean, if you get permission from the seller, I mean, could you do this? Yeah, you could. Look, you agreed to pay the buyer's agent before this all started with this NAR settlement business, 2%. I have a 5% listing. I was keeping 3% and paying the agent 2%. Can I tell buyer's agents that you're willing to consider up to 2% in concessions? Yeah, you could do that. Now, my belief is, I wouldn't present the 2%. Remember I said before, it's a trite but true negotiating principle. He who puts the first dollar amount on the table generally loses. So you tell the buyer, yeah, they'll pay 2%. And the buyer was only going to ask you for 1.5%. I think the buyer's agent and the buyer are going to figure out, well, let's bump that to 2% now because he said he'd pay 2%. See, so why would you negotiate in that style? See, I wouldn't volunteer a percentage up front. And as a buyer's agent, I wouldn't ask. You know, is your seller paying concessions? Nope, sorry. Oh, that's too bad. This house is perfect for my buyer. No, Mr. Buyer, they're not paying concessions. I can't show you the house. I don't want to show you that. What if the buyer loved the house and was willing to bump the offer a little bit? I'll let when's the seller moving? In 3 months. I'll let them stay in my house for 3 months rent free. I love that house. See, I wouldn't pre-negotiate terms until you got something on the table in front of you. So I think disclosing that 2% on the old RLA, I'm not even sure it is factually correct because that obligation is gone. So you have to choose your words very carefully. And I'm not sure it's in your seller's best interest.
Hey, Walt, that was my question,
Okay.
Bob Adams.
Yeah.
And why I'm asking is because I've
question.
already got the offer, and he had to do a modification to his contract with the buyer because he had a 2.5% and we're only offering 2%.
Right.
So in this regards, it worked out okay. So, and the seller's fine with that too. So that's why I asked the question only, and I see your point of view, but
yeah.
it worked out all right.
Yeah, look good. I mean, if the seller said he's going to pay 2% on the old RLA, and here comes an offer asking for 2.5%, my dialogue with the seller would be, well, you agreed to 2 before. Is that 2 still okay? Would you object? Ask a no. I'm going to do a seminar on some of my little negotiating tips. Ask a calibrated no question. Would you object to paying 2%? No. Ask a question where the no gives you what the yes would have given you. We're kind of a yes addicted as salespeople. If you could lose that addiction, you'd be amazed at how powerful the word no is. So would you object? Would it be a problem for you to go ahead and pay that 2%? No, that wouldn't be. Now, since you're going to pay the 2%, would it be ridiculous? We'll get the second no question. Would it be ridiculous to consider adding 0.5% because this offer is so good? It's got, possession when you want it. It's got this, it's got that, it's all cash, blah, 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 blah. Would it be ridiculous to suggest another 0.5%? As opposed to, would you pay another 0.5%? No, I don't want to pay 0.5%. Okay, now you got nothing. Would it be ridiculous to consider another 0.5%? No, that wouldn't be. When you do this calibrated, no, I shouldn't do my seminar next month today. But when you ask calibrated questions, one of the things you'll notice is people say no before they even think about it. And once they say no, they recognize they just sort of agreed to it. No, I wouldn't object. No, I don't think it's ridiculous. Well, great. Let's go ahead and have that back. Okay, that's that.
Can't we just send unrepresented buyers to SDR to purchase forms?
Can we say again?
Can't we just send unrepresented buyers to SDAR to buy forms?
Yeah, I believe you can. We're trying to figure that out. It's a moving target. I don't know if Jeff's on this call or not, but I got to thank Jeff. He's been so diligent in trying to figure out where we can send buyers. I think the current answer is, yeah, SDAR will or does have forms available. And you could try that as well. Yeah.
They're working on it.
Yeah. Yeah, I don't think it's quite. Yeah, will is that's probably the right word. I don't know if they have it quite done yet, but they're working on it.
So
Apparently, car no longer sell.
the BRBC is not a law. It's just a rule by CAR and NAR, right?
Yes.
Can you still show homes to the buyer if the buyer doesn't want to sign a BRBC?
No.
No.
And by the way, I don't know. I mean, I don't have a life. Apparently, I eat and breathe all this stuff. I've certainly got a lot of fodder. Ketchmark, who was the lead attorney for the lawsuit that started all this, was interviewed by Inman. And he made it very, very clear that he and a group of other plaintiff attorneys are going to be monitoring compliance with the NAR settlement, and they will not hesitate to file lawsuits against any entity that violates the NAR settlement. Something you should be aware of. It's kind of common sense, I think, but if it's not, I'm not. It may sound like I'm being critical. I apologize for that. Obviously, if you have a settlement and then you violate the settlement, whatever protections the settlement gave you probably don't count anymore. So, buyer and seller have a dispute and I convince the seller to write a $5,000 check and the buyer wants it by Friday, I'm not going to put that in the settlement. Why? Because I worry about, can the seller get the money to the buyer by Friday? See, because if you violate that, I went to all this trouble to get this settled and you're a day late on the 5,000 and the buyer's no longer bound by the settlement. So what they got to do with the NAR settlement? You violate the terms of the NAR settlement, you can be sued, you being the brokerage. And individual brokerages have been sued, 2 in Northern California. And again, Catchmark says we won't hesitate suing any entity that violates the NAR settlement. So do not show property to buyers you don't have representation agreements with. Why? Because that NAR settlement is very important to us. Mike is, I mean, a little self-serving pat in the back. Mike is not an insignificant broker in California. He is one of the larger RE/MAX brokers. He is the largest RE/MAX broker in San Diego. And I think the second largest in Southern California. Attorneys look for pockets. Is the attorney going to sue a mom and pop company with 3 agents? Not if they can sue Mike Safadine, RE/MAX Connections, because you guys got money. By the way, E&O doesn't cover violation of antitrust laws. So we couldn't even turn it over to do E&O. So please, 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 it bothers me a little bit. I mean, say this with a smile, with love, but you should not be thinking about, well, it's not a law yet. I don't care what NAR says. I'm not going to do it. You are a NAR member, and we are I have told agents to stay in NAR no matter what until November, because if you're not in NAR when this settlement's approved, it doesn't apply to you.
Hey, Walt?
Yeah.
So if you have a new buyer, they want to see property, would you say the best place to have them sign the BRBC is right at the property? I mean, otherwise you'd have to do DocuSign or, et cetera.
Well, I mean, that's a whole nother seminar. I mean, what's comfortable for you? My style personally is to have a consultation with the buyer, even a brief one. If I'm going to have them sign something at the property, I'm probably not going to use the BRBC. I'm probably going to use the SPRA because it's simpler and shorter. A technique. I didn't do it a lot, but once in a while I did it and it worked like a charm. I would get they didn't call them BRBCs then, they were RL, I forget what they're called. They had 3 of them, one for compensation, one for not compensation, one, exclusive, and one for not, compensation, but not, anyway. So I'd meet with the buyer and I'd have them sign a 1-day agreement. And then I would tell them, at the end of that 1 day, if they're buying one of the houses that, I had the agreement, didn't matter, I got an offer. They didn't buy the house, I would then say, and this was before I learned the dialogue of the calibrated no, so I did ask yes-oriented questions. So I would ask questions like, I think I've restructured the question today, but I would ask questions like, did you find it beneficial working with me? Are you comfortable working with me? Do you like my style? How do you feel about me helping you buy another house? If I can't make a buyer want me to be their agent after I show them 5 houses, I need to get out of the business. That's pretty blunt. I don't like to be quite that blunt. But if you show a buyer 5 or 6 houses and you haven't won them over, then call me up. We need to do some one-on-one coaching because you're going to have a real rocky road in your career. But if you can show them 5 or 6 houses, in the old days, and for most of you on this call, you didn't need buyer representation agreements because after you showed them 5 houses, they loved you so much, they wouldn't think of not using you, So my point being, 1-day agreement, they love me after 1 day. At the end of the day, okay, but before you go home, let's extend this. Modification of terms. Buyer representation agreement shall expire. And in the old days, I used to make them 6 months. Now the law will say 3 months. See, so my point being, you know, yeah, doing it at the car. Yeah, I'm not sure I'd do a BRBC at the car. You know, maybe, yeah, I would, but make it one day. Doesn't matter. Or no, I'll do a simple one. Do the PSRA, I think the letters, property showing representation agreement, which is very simple. You know, maybe I don't even change it for it's 30 days, but even I change it for one day. If you like me, I'm going to be preparing him in advance, by the way. If you like my style, if you think I know what I'm doing, before you go home tonight, we find the house. That's on my job. We're going to buy the house, hopefully. We're going to reserve. By the way, I used to use the word reserve. You know, that's a little tip, by the way. Sometimes the tips again. I would get a buyer to write an offer by telling them, let's reserve the home, not let's buy the home. Well, I need to think about it. I need to call all my advisors. I need to talk to my mom and dad. Oh, I agree. By the way, it's good dialogue. Oh, I agree. You should talk to your advisors. You should talk to your mom and dad. I don't want you to lose this house. Let's reserve this house in case they say, yeah, go ahead. See, that's kind of short version. So I used to use the word reserve frequently to get a buyer to write an offer the same day I met them. By the way, almost 40% of the buyers I worked with wrote an offer the same day I showed them 5 houses or less, and they wrote an offer on one of them. And one of the ways that worked was because they were reserving the house. You know, what happens if your trusted advisors say it's a great deal, but it's sold to somebody else? Would you be mad? Well, yeah, okay, well, let's reserve it so that doesn't happen to you. All right, so I'm going to get the 1 day signed, and then I'm going to tell them when they sign it, if you like my style, before you know, if we find a house, it won't matter. We don't find a house, I want to go to work for you. I'll get a better idea of how to help you. And I'll ask you that, you know, we'll talk about extending this. So I'm going to present that and then have them sign it and then later have it extended. Hope that helps.
Yeah, so we have a couple other questions, but I
Yeah.
just took note of them and I'll have you just answer them offline.
Okay, so we're going to wrap it up.
Yes.
All right, folks, thanks for hanging out. Thanks for getting all of your questions to us. And to the extent that the questions have some general applicability, we'll put out an agent hub to answer them. Want to thank everybody for being on the call. Thank you for all your hard work on trying to learn all of this. And, you know, like I said, you got any questions or problems, reach out to us. We're here to help. Y'all
Thanks,
take
Thanks,
care.
Walt.
Great
Thank you,
day.
Walt. Bye, everybody.
Bye.
Thank you,
Bye.
Walt.
See ya.